Welcome and thank you for joining Seifarth's webinar, California Website Owners, Key Updates on Cookie Banners, Arbitration, and Privacy Compliance. All participants are in listen-only mode, but are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. We've recently introduced a streamlined process for accessing and submitting CLE forms. Towards the end of the presentation, you will notice a QR code on the left-hand side and all the necessary information on the right. Simply scan the QR code with your smartphone and it will direct you to a digital attendance verification form. Once you've completed the form, you can submit it electronically. This saves time and ensures accurate processing of your CLE credits. Copies of the webinar recording and presentation materials, along with the CLE form, will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Gina to get us started.
Thank you, Brenda. So today I'm joined by Kathleen McConnell and Vince Smolczynski. We're three of the team members at Seifarth that handle a number of these cases. We have a much larger bench, but today we thought it would be a nice grouping to have both our privacy lawyers and our litigators together to talk to you about these recent trends and the rises of these claims. I have been a consumer class action attorney for over 20 years. I have been on both sides of the plaintiffs and the defense bar, and I've been working on these types of privacy claims in the consumer class action space for about 2 to 3 years, and I usually pair with Kathleen and Vince because of their technical know-how, and you're going to see why that's a nice pairing and why Seifarth as a firm puts together a team on that based on what we're going to present you today. Kathleen?
So I'm Kathleen McConnell. I am a partner here in the San Francisco office of Seifarth Shaw. And my practice, as Gina alluded to, is really data focused. It's really all things data, kind of with a significant component that's focused on CCPA, CPRA compliance, and other state level data privacy regimes, along with handling a number of these California Invasion of Privacy Act cases over the last several years as these have started to gain more momentum, particularly here in California with some similar statutes in other cases, in other states. I also head up our data science team where we focus on providing insight and leverage to clients through data visualization and quantification.
Hi, everyone. I'm Vince Smolczynski. I'm in the Charlotte, North Carolina office of Seifarth Shaw, previously of the Chicago office. As you might have guessed, my practice is focused in data privacy. I was actually, when I first started practicing, an intellectual property attorney by trade, still am, and did all aspects of litigation, prosecution, and counseling on the intellectual property side. And then over the last several years have really started to focus and start counseling clients on data privacy issues, CPRA, the kind of plethora of new state statutory schemes that are coming into be seemingly on a weekly, if not monthly basis, as well as Gina mentioned, getting involved and helping our clients handle the newly filed demand letters and complaints that we are seeing under the SIPA statutes.
Next slide, please. So the next slide will show you our agenda for today. It's a bit of a roadmap of the things we're going to talk about. We'll start with what SIPA is, and then we're going to talk about a very important topic that we hear about a fair amount, which is, but I'm complying with other regulations. Why do I now have risk here? In order to understand what's being alleged, we're going to get a good summary from the more technical folks on this call about what technologies are being alleged that are violating or triggering a SIPA violation. We'll give you some context in where the recent trends and cases are, and then talk to you about ways in which you can reduce risk, both from a defense argument, how to respond to a demand, and simply just positioning yourself for dealing with all of these intersecting demands from different regulations and consumer privacy claims. And lastly, because many of these claims arise out of websites in general, to the extent your websites have arbitration provisions. There have been a number of considerations that you should know about whether or not you want to continue with arbitrations based on that cost. Next slide, please. So how did we get here? If you're not familiar with SEPA, but you are familiar with the ADA website compliance cases, looks a lot like those cases and operates a lot like those cases. I sometimes tell our new clients when we're meeting and they're asking what this is about, I say, I think the plaintiff's bar just exhausted all their ADA website compliance claims and moved over to these claims. They're exploding in the same way those cases or those demands move forward in the ADA space. In the last few years, we've seen several hundred lawsuits by the same 4 to 5 law firms and thousands more demands, and we don't know how many arbitrations have actually gone forward because, again, those are pretty confidential, but or they are confidential. But we are members of the defense bar, so we hear that those are exploding as well. Where do they come from? What do they mean? Well, again, the plaintiff's bar dug deep into California law, picked some Soviet-era penal code statutes that related to wiretapping and tracing and listening in on telephones and telegrams, and said, hey, when you follow somebody around a website, if you're collecting their personal data without their consent, it must violate these penal code statutes. And congratulations for the plaintiff's bar. It's $5,000 every time data is collected, not just one visit, $5,000 every time data is collected as somebody moves through your website. Oh, and there's attorney's fees. So we'll get to this in a little bit. Thousands of lawsuits have been filed, like I said, many, many demand letters, usually the same players, but we really haven't gotten to the merits of these cases. So there's been a few companies that have decided to test these on motions to dismiss, and so we have some case law around that. But usually the way these cases are being handled, unless they move to mass arbitrations, which we're going to discuss later, is there's really an attempt at settlement. Again, similar to the other type of statutory consumer claims that we've seen in the last 10, 15 years in California. California is not the only place for risk for you. We're seeing similar claims in many other states and federal claims, and we expect each of the states that you're seeing on this slide, the Floridas, the Illinois, the Massachusetts, the New Yorks of the world, potentially Connecticut too, not listed here, will pick up and follow suit to California's leadership in this space. Next slide.
Yeah, so where do these lawsuits stem from? As Gina mentioned, they are based largely or solely on the penal code under the California statutes that were developed in many cases 50, 60, if not more years ago, with the idea of limiting the recordation and eavesdropping on telephone and telegraphic communications. And they stem primarily from 4 different sections of the California Penal Code. They sound very similar. There are some small nuances amongst the different sections. Under 631, you've got your third-party wiretapping and in-transit interceptions. Under 631, there's really 4 subsections. You know, it can relate to intentionally tapping a telegraph or telephone wire. Under the second section, it involves willfully and without the consent of all the parties, learning the contents of the communication. The third section involves the use of the information that was derived from one of the first 2, either tapping or learning of the contents. And then fourth is the aiding or abetting the use of that tapping. Under 632, you've got monitoring or recording of confidential communications. This can be whether either in person or over a telegraph or a telephone line. 632.7 again relates to the interception and recording of a communication between 2 telephone lines. And then 638.51, more commonly called the pen register or the trap and trace statute, relates to the installation of a pen register or a trap and trace. So what is that? What is such a device? statute defines a trap and trace device or a pen register as a device or process that records and captures the dialing, routing, addressing, or signaling information from a wire or electronic communication. But this doesn't involve recording or capturing the actual contents of the communication. Under each of these statutes, the statutory damages per violation per visit can be up to $5,000, or it can actually be trebled. And there is a private right of action that is attached under the California Penal Code with no actual damages that are actually necessary. And we can get into how this interplays with the CPRA and the other state statutory schemes. Actually, next slide. So that actually leads nicely into the next section. And many of the questions that we're often presented with is, I've been focusing on CPRA compliance, these other state statutory schemes and regulations that are coming into place. We've been operating in the EU. We're buttoned up on GDPR compliance. What does this mean? Well, and the short answer is compliance with one does not necessarily mean compliance with other. These are really arising out of two different statutes, one being focused on the data privacy issues and ensuring compliance under those regulations. And then you have the SIPA scheme, which the plaintiff's bar has kind of dug into to interpret it, or at least get the courts to try to interpret in a manner such that it would apply to these electronic communications. And the big reason why is because under the CPRA and the CCPA, as well as the other state statutory schemes, and I feel confident saying this today, this may not be true in several weeks' time, but at least as of right now, none of these state privacy regimes provide for a private right of action, although the California regulations do provide for a private right of action in the limited instance of a data breach. Otherwise, the data privacy regulations are going to be enforced by either the Attorney General or a regulatory board that is put in charge of enforcing those statutes. The fines for data privacy compliance are similar but not the same. You're looking at $2,500 per violation. This under California. Those violations are assessed on a per consumer basis. They can be trebled up to $7,500 per intentional violation. But I think the long and the short of it is that while compliance with CPRA is obviously a consideration and something to be aware of as you're running your website, figuring out the functionality, does not necessarily mean that you won't find yourself on the receiving end of a SIPA demand letter, given the plethora of new disputes that we are currently seeing. And Kathleen, I don't know if you have anything else to add, but that kind of illustrates the interplay between the two.
Yeah, I'd say one of the questions we get frequently is just this issue of like, we spend so much time and energy focusing on CCPA, CPRA compliance, or even more on EU-driven GDPR compliance. And it's frustrating to legal teams and in-house IT teams that the overlap is similar across all those statutes and across the requirements under SIPA, but it's not exactly the same. So you can be perfectly compliant with the GDPR requirements, you can be perfectly compliant with the CCPA requirements, but yet still find potential exposure under SIPA due to the current still lack of clarity in the law. But a lot of these cases are at least getting past the demur motion to dismiss stage. So just highlighting there that just because you're compliant on one front doesn't necessarily mean you're completely protected on the SIPA exposure front.
Next slide, please.
Okay, so we're going to spend a little bit of time here talking about what technologies are really driving the impetus behind these demand letters. We're going to talk at a high level about cookies, pixels, web beacons, tags, what those different technologies do, claims that we're seeing focused around those elements. We're also seeing a number of demand letters around the interaction of chatbots, including recordings, third-party data sharing that happens there, and other and use of information collected from chatbots. Some claims around kind of doxing or de-anonymization cases, which is basically reverse engineering a visitor to the website's identity or business. Some claims around session replay, and then most recently we are seeing claims coming really around the operation of search term functionality within a website. So one of the things that that does come up a lot when we're talking to in-house IT and legal teams is people can get very focused on the difference on the imprecision with which the legal world uses cookies, pixels, web beacons, tags, and there's a lot of similarity between some of those functionality and differences between the others. But really, the upshot for that set of communications and really all these communications under SIPA is that you're looking for transmissions that are happening to a third party that are not really strictly necessary for the operation of the website. That's really where the exposure or the potential exposure is coming under these claims. So some kind of background technology for those on the call that might not be coming from the IT side on this is some terms that are helpful to know is that you've got servers which deliver information to your computer. You've then got web servers which deliver websites, and you also have ad servers which deliver, shockingly, ads. When you're dealing with cookies, a cookie is basically a piece of code that gets placed onto your browser by a web server. When you're dealing with what we call first-party cookies, those are pretty easy to identify and kind of understand how they operate because they are placed by a website that you go to directly. So if you were to come to, let's say I have a website that's Kathleen's Shoes and I sell shoes on it. If you were to come to Kathleen's Shoes and I were to place a cookie on your browser, that would be a first-party cookie. There are different kinds of both first and third-party cookies. We've got a range from necessary cookies that are really integral to making the website function at its base core functionality, to performance-based cookies or functional type cookies, which can be things like, if you come to my website, I may remember that you've logged in before, and that saved login information is cookie driven. Then you also have things that are more targeting, advertising, or analytics-based cookies. So those are the ones that tend to be more third-party implicating type, the analytics, the targeting, and the advertising type cookies. Again, there's a little bit of fuzziness around the terms for all of these, but that's typically kind of the range of how you'll see them defined. And those concepts apply whether or not you're strictly dealing with cookies or whether you're dealing with pixels or tags or web beacons, anything across that spectrum. So one thing to keep in mind is that servers don't talk to each other, and that's where pixels kind of come into play. So for example, you might have on my website, you might have a website, someone saw your ad on Instagram and then came to your website and purchased your product. You might want to know that the purchase was a direct result of that ad being seen on Instagram or Facebook or wherever else it might be, so that you can think, oh, that worked really successfully, let's place more ads there. That's where pixels come into play. They really kind of drive that communication across servers. It's really the workaround to servers not talking directly to each other. So, and when you think about a pixel, like you can kind of think about those old pixelated images, right? Where you've got like a bunch of like kind of big squares of image. And the modern pixels are really kind of the same thing. It's a minute area of illumination that is placed on a website, and it's often transparent. And once it's placed, typically the only folks that know that it's there are the advertiser that placed it and the website owners. So anytime that your browser downloads a page or an email, the pixel downloads with it just like any other image. So what's kind of the extent of what these third-party cookies, pixels, communications can do? The third-party nature of these, it makes it so that it's not just looking at what you're doing on one web page. It's really using these different technologies to kind of accumulate data gathered across browsing sessions to kind of create a picture of a user with the information. So when the type of information that's collected is, there's a unique identifier for consumer that is created so that that consumer is recognized when they visit different sites, particularly different sites belonging to the same ad network or platform. It'll remember sites that you visited, products that you viewed, products that you might have put in your cart, ads that you've clicked on. So while first-party cookies don't go beyond the site that you're looking at, these third-party technologies are not restricted in that way. Basically, the third-party cookies will sit there, wait until you land on a page where your unique identifier is recognized, and then gather information while you're on that site. So if you're on a page that has sold space to an ad network, they might recognize you yet again and then place the relevant ad based on that information they've gathered, correlated with other places that you've been that day, earlier that day, other days. It really enables the companies to kind of build a profile about you and make assumptions about your interests that allows them to serve ads to you that they think are reasonably tailored to what you might be interested in. To give this kind of a real world example, let's say as I mentioned before, have a shoe store. I purchase ad space from an ad platform that has purchased real estate on multiple websites. So let's say they've purchased real estate on Instagram and on Facebook and other websites as well. Then you come to my website, Kathleen Shoes. I place a cookie on your computer for basic tracking. That cookie doesn't talk to the ad platforms, but I also have a pixel on my website from the ad platform. The ad company has an ad server that then places a cookie on your computer. Now the ad company knows that you visited my website using that combination of technology. So that ad company then has access to all the other websites that have sold real estate to that ad platform, which means that it's likely that the ad for my shoes will show up for you on another website that you visit. So because I told the ads company that I wanted to retarget people who have been to my website before, it will make them more likely to serve ads to you as you travel through the other websites. So all of that works because the ad company knows, because of the cookie that they placed on your computer through the pixel that I placed on my website, how that all ties together. So that's just kind of a low-tech explanation of the back-end technology that's at operation here. A lot of the demand letters that we're seeing are really kind of, Metapixel is a huge one. That's very, very common in terms of demand letters. Other pixels in general, TikTok, a number of different third-party pixels are an issue. Another one, as I mentioned previously, is we are seeing a lot of chatbot-driven demand letters as well. And those really come from a couple of different aspects of the chatbot operation. One aspect that we're seeing claims around is the recording aspect in and of itself, that you may or may not have disclosed whether communications that are submitted through the chatbot are recorded. So disclosures around that can be helpful for discouraging potential claims around that issue. A big part of it, of the ones that we've seen lately, are really the third-party data sharing. So most companies are not hosting their own chatbots. There are a handful of clients out there that are doing that, but the vast majority are using a third party in order to host those chatbots. So that disclosure of going even to the third party that is operating that chatbot is a lot of what's driving some of these cases. Particularly, or more or less so, depending on what restrictions are around that party's use of the data. And if that information that is being collected through the chatbot might also be being analyzed by other third-party tools that you might be using. So it may not only be going to the party that's hosting the chatbot, but perhaps you're using the information that's submitted through the chatbot and you're letting some of your other analytics tools run on it for a number of, very valid business reasons. So those types of claims, not only of the hoster of the chatbot, but also of third parties analyzing that data that you might be using to analyze that data, either for your benefit or for a mixed benefit between yours and theirs. And then also,
may I
yes.
just quickly say, it's really tricky there with chatbots, right? Because what we hear is, in order for the bot to chat with you, you need to enter in some information so that you can exchange information back and forth, like your email address or your phone number. And the questions that are arising is that sharing this PII or other information in that moment such that SEP is triggered?
Yeah. And then another aspect with chatbots to keep in mind is, what are you doing with the information that is submitted through the chatbot? And do you have disclosures in place around that? If you're only using it to respond to the question that's submitted or the immediate request that's submitted, your disclosures might look a little different than if you're using that information for, say, follow-up for future marketing or advertising practices. So things to keep in mind, that actually come into play both in the SIPA and outside the SIPA context as well. I'm going to be quick for these last couple because I'm going a little over time for this slide. But a couple of the other types of claims that we're seeing, and I touched on this briefly, are kind of the doxing or de-anonymization type suits, type claims, where basically there are a number of different softwares out there that will reverse engineer the identity of a visitor to a website. And often those are used for lead generation. Often in the business to business context, it comes up frequently there where you might be identifying that you had a visitor from X company that came to your site. So those types of claims we're seeing at issue. Session replay, which is really a functionality of kind of continuous tracking of what someone's doing across your website that can be used in a variety of ways for analysis and marketing purposes. And then again, I think I briefly touched on this one earlier, search terms. And this is a very recent one that we're seeing of the transmission of search terms that are submitted through a search functionality within a website, potentially going to third parties without disclosures around those. So those are kind of the most common website tracking technologies that we see driving a lot of the demand letters in this space. Next slide.
And yeah, I stole some of Kathleen's time, so I'll try to be quick on the first two topics here. So Javier is a great place to start. It's frequently cited by the plaintiff's bar. There, the session replay was at issue. So the plaintiff brought claims under Section 631 of SIPA against a website operator, saying that the website was following mouse clicks and movements and typing, et cetera, as people moved throughout the website. A great example of where we stand with the way these claims are challenged, it just recently was dismissed on the 5th motion to dismiss, so very pricey, costly for the defense to challenge these claims. So what happened? The session replay was used to connect consumers with personalized insurance plans on a particular need or budget. Once the consumer had put in their basic information, they clicked on view, provide me a quote or view a quote, and that popped up a consent, if you will. By agreeing to this, you agree to our privacy policy. Okay, so a lot of movement throughout the website before that consent moment. After the first motion to dismiss in 2022, the matter went up to the Ninth Circuit, and what the Ninth Circuit said is exactly here on this slide. Yes, session replay is invoked by SIPA, and internet communications doesn't matter that it's not the telephone or a telegram or telegraph. All right, and so that's why the plaintiff's bar likes it. Came back down to the Northern District, and a couple arguments were made by the defense. Was there implied consent at the moment the user came to the website to use the services? Was there really a third party involved, such that somebody was quote unquote eavesdropping when an agent collected the data, and whether the statute of limitations had run? So in a couple of the first rounds, what we got out of the district court was, no, it's not implied consent at the first instance that a user comes to the website and wants to obtain this product, because the information with the privacy policy happens later. And two, it's not, you cannot say that this all lived within the ecosystem where a third party wasn't eavesdropping. They're on a motion to dismiss only, not on the merits, everybody. So they did not, the Northern District did not accept that argument and said, really, the third party provider that you're providing that information to is getting this information, and it's akin to eavesdropping. What's really interesting to me is the most recent decision on whether or not the plaintiffs brought the claims soon enough. And this gets closer to some merits arguments that we want to make is, as defendants, as we get further along, the case was dismissed because the Northern District said, no, once you clicked on view my quote and accepted the privacy policy, you plaintiff were on notice that this data or information might be collected, and you didn't bring a lawsuit within the 1-year statute of limitations for these claims. So a mixed bag for the defense bar, but a lot of still arguments viable, especially because we have differing decisions in differing courts, state courts and federal courts. Greenlee came out late last year. That was one of the first pen register or track and trace cases that we saw. And so what Vince told you is it's the tapping of your phone and not the actual recording of the communication, both incoming and outgoing communications. And what happened in Greenlee is a software was installed on a third-party mobile device and did exactly the trapping and tracing, well, allegedly tracked and traced as the user moved throughout the application and on and off the application. The Southern California court that handled the case looked at the language of the pen register and interpreted it very broadly. What the court concluded was we should focus less on the form of data collected and more on the result, because the statute uses the word process. And the software identified, gathered data, correlated that data, and gave a unique fingerprinting through the process, and thus it met the pen register definition. As soon as we received that decision, we had an explosion in claims from demands, claims from plaintiffs' counsel, and they're moving away from the 631 claims and sitting in these pen register claims. I think that is now Kathleen.
So the state court is I'd have to say as a kind of a general rule, cases have not gone great for defendants at the motion to dismiss demurrer stage. By and large, courts have been letting claims get past that stage. We do have one good case out of California, out of Southern California at the state court level. But we also have some not great cases out of California at the state court level as well. So probably the most encouraging case we've seen at the state court level in California so far is the Lycea versus Hickory Farms case. And there, the court was not so much convinced by the plaintiff's argument that the IP address is a unique fingerprint such that it would be the same as the unique fingerprinting that was set forth in the Greenlee matter. And so not only were they not convinced about just an IP address being sufficient to trigger SIPA exposure, but they also said they were not particularly impressed by the lack of detail in the plaintiff's complaint. They said that it was really unclear how information was acquired based on the way the complaint was pled. And then probably more interestingly, this seems to be the only court that has taken into account kind of the public policy considerations of if you are interpreting the SIPA requirements in the way that a lot of courts are to let these get past motion to dismiss stages, it really represents a massive change to how the internet has to operate, to how businesses operate on the internet. And they really thought it kind of went against public policy to have that kind of disruption coming from a statute that wasn't targeted towards this type of monitoring. At least that's what we on defense bar side would argue. So that is an encouraging case. They did not let the complaint stand in that instance. However, at the same time, you have cases like the Levings matter where the court, super short case, and basically just said your argument that going to the website equals consent is not going to fly. Like just going to the website is not sufficient to say that you've consented to these types of transmissions happening. Complaint, please progress. So really mixed bag on the state court front, and I'll turn it over to Vince from there.
Thanks, Kathleen. Yeah, so I guess the last case under the pen register trap and trace cases, this is actually a case out of the Central District of California, so the district court level, but is one of the more recent cases under 638.51, and also demonstrates one of the newer, I guess, technologies that are being alleged that we're starting to see. It relates to the TikTok software, which is a software that's installed on the website, embedded within the website code, and it allows for what they call fingerprinting. And essentially what this does is it collects data from anonymous users to the website and then cross-references that with the data that TikTok has in its database in order to match up whether it's IP address, geolocation, different device data, and whatnot to match the anonymous user from the website to the TikTok user profile. And so this was brought under the pen register statute. The defendants filed a motion to dismiss, kind of putting forth all of your standard defenses that you would have expected, and the trial court shot them down one by one. Found that the software installed on the website constituted or fell within the scope of a trap and trace device. It found that the TikTok software did not constitute an exception, which is enumerated in the statute, namely, if the device is installed to help maintain or operate the communication line, then it would not constitute a trap and trace device. The court said, no, this TikTok software device, at least at the pleading stage, has been plausibly alleged to constitute a trap and trace device that is not within the exception. The court also did not find that the that the user had consented to the collection of this data, and that the info that is collected, namely, like I had mentioned, the IP address, the geolocation, browser data, this was the type of information that a trap and trace device would typically collect. It did not constitute the contents of the communication. As we mentioned, the trap and trace devices don't relate to the contents of the communication. It relates to kind of this signaling data. So recent case kind of fall more in line with the Levings decision than the Lycia decision, but demonstrating again kind of that these cases are making it through the motion to dismiss stage. On the chatbot front, these two cases are interesting primarily because of the different results that these courts came to within a short period of time, about 6 months apart. Different courts, obviously Central District of California for the Byers decision, that was Judge Sykes. And then in the Swartz decision out of the Northern District of California and Judge Tiger. But this involved, embedded software and chatbot functionality where the user entered personal information, kind of all the typical standard factual scenarios that you'll see in these demand letters, in that the third-party provider of the chatbot functionality was recording and transmitting the chatbot communication without the user's consent. In the Byers decision, the defendant's motion to dismiss was denied. Judge Sykes in that decision found that all of the requirements for a potential claim under 631 and 632.7, so including that trap and trace, and then also the interception statute, the communication interception statute under 631 had been met. In comparison, in the Swartz decision, Judge Tiger took a different tact and really focused on the language of the statute and found that they had been narrowly drafted to apply only to what would be considered the quintessential telephone or telegraph lines and could not be expanded out to cover electronic communications. And this was true even despite the fact that the plaintiff in that case had accessed the defendant's website via a smartphone while in California. So even though a telephone per se was used, it was not a telephone line or a telegraph line as was contemplated by the statute. So, these two cases kind of, again, showing the disparate or the different ways that courts are interpreting these statutes and applying them to the facts that they're presented with. And, kind of the lack of clarity that we're currently dealing with on this front.
I think that these decisions all illustrate some practical considerations that we have just generally for litigation in California, right? There's a permissive pleading. The courts are inclined to find in favor of plaintiffs, even in federal court, in order for them to maintain their claims. And there is a struggle around interpreting the statutes, right? And finally, a struggle we can tell from the courts on understanding the technology, right? We have two different judges in the chatbot cases that interpret both the penal code and the technology in different ways. We think that that's very important for you as clients in listing the right team to be able to communicate about the technology. both with internally with the clients and externally to the court. And as more of these cases come down, we're going to see, hopefully, the judges becoming more educated on both statutory interpretation and the technology itself. Where we don't have judges involved are where we see the demands. So typically the way each of you as a client is going to see, at least early on, is a letter from a number of law firms that's only a few pages long and says, we demand you do this, or we're going to file a class action, or we're going to invoke your arbitration provision. And there are some concerns with how arbitrations have been proceeding en masse and the costs of those. We'll talk about those later. And as we move into what can you do to respond to these demands or decrease risk, I'm just going to put a pin in one of the latest claims we've seen in a demand, which is, okay, you company have put up a cookies banner, meaning you're invoking consent before all of this data is collected in this, or not, in the sense of you can accept the cookies, manage the cookies, or decline cookies, reject cookies. Some savvy plaintiffs' lawyers have found situations with their own technology experts where a consumer, a user, has said, I do not want cookies running when I'm moving throughout the website, and indeed cookies are still being collected, meaning the functionality from a technical standpoint within your business, within your website, it just didn't work as intended. So we're seeing those claims. So once you do what Kathleen's going to say to do next, suggests as options for illustrating some type of consent, you should make sure it's working. Next slide. Oh, no, it's me. Sorry. Next slide again. So I was talking about consent as a defense. So I'm sorry. I jumped to the practical approaches. So when we talked about each of these cases, you've seen that there's been minimal success on a motion to dismiss, a failure to state a claim, for the reasons I just stated. And similar with the arguments on lack of personal jurisdiction and lack of injury. I mean, really what we've seen is the courts being very permissive on who can be a plaintiff, including case law that says, we don't really care that you plaintiffs bar have professional plaintiffs. We see all the same people named on the demands that our clients get. A lot of the plaintiffs are the same in the cases that go to a motion to dismiss, and folks are just going to the website to gin up these claims. Courts have not dismissed cases for those reasons and have not found that the cases were unviable because there was a lack of injury. Especially in California, there is a conclusion that, like, once your data is taken, your privacy has been violated and you've been harmed. As Vince already pointed out, and then we talked a little bit in some of these cases, I mean, you can't eavesdrop if there's no third party. So some of the defenses that have been successful in the defense bar is really this communication isn't going outside the company. It's used for the functionality of the website. There's no eavesdropping, so there's no third party communication. And in certain instances, we'll talk about this when we're talking about compelling arbitration or not, different defendants have decided to compel arbitration in court to see if they can actually learn about who the claimants are, because the claimants would have to explain why they didn't agree to the arbitration provision. So there's ways in which to discover some of the underlying claims, and there's been minor success in some of these defenses at the pleading stage. Embedded into each of these penal code sections is consent. So when we're talking about risk mitigation and we're talking about defenses, we look at ways in which you can prove to the courts or opposing counsel, if we're looking at demands, or the arbitrator about, no, the claimants knew exactly what was being collected and consented to that collecting. So here you can see on the slide, the best practice would be clicking on a button and explaining what that data collection is, usually through the T's and C's of the privacy policy conspicuously provided. It doesn't have to be in one form. It's not explicitly required. That's not into any regulation, but these are just options that you have in order to show that consent. And again, including warning language in your website or your chatbot feature about how that usage of that information is going to move forward are good indicia of consent. And now we're going to move to the slide that I previewed previously. Kathleen?
So thinking about kind of positioning your organization for success, and also keeping in mind that there's a lot of unsettledness around the law in this space right now. We have, some early decisions by courts at motion to dismiss or demur stages, but very little substantive, really merits-based decisions. There are business considerations around how one approaches marketing and disclosures and things. We understand that, there's a lot of different competing things going on with how you may choose to approach your cookie management, approach your disclosures. But things that you want to think about in that process are, if you want to go, a more conservative route and make sure you're kind of shored up against the potential exposure as it's being presented right now under the SIPA claims, one of the ways to do that is to basically front the information, front the disclosures, so that you can really shore up a consent defense. And that's really what cookie banners, what disclosures are all about, is giving notice in advance before transmissions happen to give the visitor to the website a chance to meaningfully make a decision about how their data is being handled before that happens, so that if they do proceed or consent to the transmissions, that you then are able to say, we have clear consent from this user. And keep in mind that, even what raises the level of consent is a little bit of a gray area, right? And some states might interpret that a little bit differently than others. We don't have a lot of guidance in California yet on exactly what will be required to equate to consent. But things to keep in mind, again, as you're trying to kind of mitigate this risk, are, do you have a cookie management banner in place? And not only do you have something that kind of pops up and says cookies are in operation, but are you allowing people to make a meaningful decision about how they want those cookies to be operating? Are you going to provide a accept all, a reject all, a management option? Are you going to make those choices required at the outset? Are you going to force people to not be able to interact with the website if they don't make a choice? When you're checking for what cookies and pixels are operating, one thing to be cognizant of is that it's not the same for every page across your website, right? So you may have everything kind of within your scope of what's happening on your main landing page, but are there things that are firing or transmissions that are taking place on some of the pages beyond the landing page that you need to be thinking about in terms of your disclosures and your management options? At what point does the transmission take place? In a most conservative world, you will not have any unnecessary third-party transmissions take place before a decision is made. And again, there may be business reasons to handle that differently, but if you want to go the most conservative route, you would not have any unnecessary third-party transmissions take place before somebody makes a decision about how they want their cookies, pixels, tracking technologies, all those things to be handled. And keeping in mind that you do want to, again, if you're trying to tackle this from the most conservative standpoint, make sure that your language is not only encompassing cookies, but also kind of more broadly, more tracking technologies, because each of these technologies are a little bit different in terms of what they do and how they operate, and most laymen are not going to understand the difference between that. So you want to try to make those disclosures, and you're always walking a fine line with privacy of saying enough that you've made a disclosure without saying so much that you confuse the visitor. Good times. But anyway, so making sure that your privacy notices, both the cookie, any cookie banner that you have up, and then also the privacy policies and notices themselves that on your website, do those accurately and fully disclose what you have operating on the site. Kind of related to that, if you're going to have a chatbot in operation on your site, you want to think about, do you have the right disclosures in place for that? Are you using the data that's coming in through, or is there any kind of analytics that's happening on the data that gets submitted through those chatbots? How are you using that data down the line? Do you need disclosures in place about that? Are you using it for future advertising or marketing? Is your chatbot, hosted by a third party? Can you have your disclosure about the chatbot kind of linked to the relevant provisions in your privacy policy to give a more fulsome description of what you're doing with the data so that you've got some disclosure in the chatbot, but your privacy policy also kind of talks more fulsomely about what you're doing with that. Are you testing you want to think about are you testing the technology to make sure that it's operating right? To the extent that you've got global privacy controls in place to honor opt-out requests, is that working? To the extent that you have management options for cookies, whether it's reject all unnecessary or some kind of management, that's short of rejecting all, but are the cookies pixels tracking technologies then operating consistently with what the user's election is? And honestly, websites change all the time. You're constantly posting new products. You're constantly making a lot of clients are constantly making changes to their website. So this is also not the type of thing that you can kind of test once and never have to worry about it again. You might want to think about should we be testing this periodically? Do we want to tie it into when we make changes to the website? Do we just want to do it, periodically? So just, things to think about kind of depending on how conservative you want to be approaching this issue currently.
And one thing I think is worth noting here, and I don't want it to get lost as you're considering, how to go about this, how to implement your cookie banner disclosures, your chatbot disclosures, is the fact that it's quite possible that some people sitting here listening today or listening to a recording at some later time are sitting here thinking, well, CPRA doesn't apply to me because I don't meet the $25 million annual gross revenue threshold, so this really isn't of concern. The short answer is it potentially is, because the SIPA allegations, whether it's a demand or a complaint filed in state or federal court, there's no threshold requirement to be subject to SIPA. In comparison, CPRA, to have those obligations, you have to meet the threshold requirements. Typically, it's the $25 million threshold. But so the short answer is yes. Even if CPRA does not apply, you still may find yourself on the receiving end of one of these SIPA demand letters. Whether that requires a cookie pop-up policy or not, again, that's part of the business decision and understanding kind of how you want to go about approaching this, whether you're going to take a uber conservative approach to it, whether you're more risk tolerant towards it, and how you want to go about structuring the functionality and the operation of that cookie banner. Yeah, I just wanted to make sure that we were not blending the two and making sure that, anyone who's listening here understands. It kind of relates to a question it looks like we received, so that we understand that SIPA and CPRA, those thresholds don't apply to both. Sorry, the CPRA threshold doesn't apply to SIPA, is a better way to say that.
So let's move on to whether or not you actually want to be in arbitration. Next slide. So as many of you might know on the phone, that we have a law in California that if you do not, as the respondent, keep up with your both initial arbitration fees or fees within, as the arbitration proceeds, pursuant to California statute and case law, if the arbitration is dismissed with whatever provider you're working with, the state court is required to impose certain sanctions, including evidentiary sanctions, and can choose to set forth a default against you as a discretionary sanction. And here, where we have statutes with at least a $5,000 statutory penalty, it's pretty, or the plaintiff's bar at least, thinks that they have a good argument for proving up a default with no other evidence other than $5,000 times however many claimants might be involved. So for many, many years, there's been a thought that arbitration is best. I think you should be thinking very critically about this as a business, especially because what's been happening in mass arbitrations for the last 10 years. It hasn't just been happening in this SIPA space, but it is well illustrated in the SIPA space. So when you have a mass arbitration for every single person who's visited your website and information has been collected such that it might trigger SEPA. Until recently, JAMS and AAA had a requirement that for each of those potential claimants, you had to pay $5,000 or $10,000 just to initiate the claim. And so we'd have thousands and thousands and thousands of folks visiting websites, and the requirement that you pay the initiation fee could be, or face a potential default in state court, could be an 8-figure sum. So that default, along with the fees that were required at JAMS or AAA, was the tail wagging the dog for an early settlement and an 8-figure number for folks. AAA last year came out and said, we think this is bad business, and fixed that issue if you meet certain requirements within notices, et cetera. JAMS finally also made that business decision actually only until this year. But what it does require in JAMS is that your current arbitration provision lists word by word what JAMS says needs to be paid for a mass arbitration. So if you have JAMS in your arbitration agreements and you haven't updated it to include that language to drive the cost of the initial fee down to $25,000, $30,000, $50,000 versus, let's say, $10 million, you should be looking at that. So you may want a class action. You'll get class certification and class help in a way, and you may get if you litigate the class with discovery, you're going to get something more than what we're seeing in these arbitration claims, which is just a list of claimants that are responding to social media inquiries. I see that we only have a few more minutes, so let me just be really quick. One of the ways the defense bar has dealt with the intersection between the JAMS fees and the default considerations in California is to not pay the fees, let it roll into state court, and then try to compel arbitration from there. That has had varying success, but in the L'Occitane case, it had great success, which happened this week, because the federal court judge said that, well, each of the plaintiffs need to claim why the arbitration provision doesn't apply with a declaration and make their claims. And what immediately became clear was that a very small percentage of these alleged claimants, thousands and thousands and thousands, really actually wanted to make a claim. Just so you know, if you do that, what L'Occitane did was it actually named its consumers. So a big, bold move. If I start talking now, I'm going to start talking in a little bit about your strategy for an arbitration provision. Or I guess I'll do that and then I'll give you the CLE. So if you want to keep an arbitration provision, put in those arbitration provisions. These are some of the suggestions we have for you. Pre-dispute requirements, so you can actually know who these claimants are rather than just receiving a list of claimants who allegedly came to your website. Because in most cases, our clients aren't able to tell us who has come to the website because they're not actually tracking, tracing, or collecting the data that the claimants are alleging. Make them exhaust certain remedies by going through mediations and not the arbitration proceedings. Again, check your AAA and JAMS language so you can invoke the lower initiation costs. Add a Rule 11 requirement in there so that the plaintiff's lawyers can't just simply say, oh, well, I think we have a claim and I think you're doing something unlawful, and I have 1,000 people that signed on to a social media push. And also make it required that each of the claimants, the thousands of claimants or the tens of claimants, need to sign the actual documents rather than the plaintiff's lawyers. I think that'll drive your claims way down. And then you want to just get ahead of how you're going to proceed in the arbitration with either batching or bellwethering. Whether or not all of this is going to be too onerous eventually, we haven't had those decisions yet. So again, just considerations and whether or not they'll be enforceable, and maybe add procedures for determining lead counsel and eliminating duplicate claims. Again, these aren't all surefire ways to change the way the arbitration proceedings are going forward or to ensure arbitration. As I'm sure folks know on this phone, there are all kinds of decisions in California on whether or not the arbitration provisions are enforceable because of their content and how they are provided to the user, click wrap, browse wrap, but these are some considerations you should be looking at if you're going to continue with your arbitration provision. All right, and now the CLE code. thank you for hanging in there with me and hanging in there, even though I spoiled, I got too excited about the CLE code. So this is our new CLE process. Please use your phone, scan the QR code, and that will then bring you to an attendance form where you can fill out the information that's required for you to receive credit for today. With that, unless Kathleen or Vince says something more, we'd like to thank you very much for joining us, and have a nice afternoon.